Now, attorney at law, Florida Bar, and fellow in public law and justice at CDD Ghana, Professor Asare, is arguing that the provisions for a presiding or Speaker of Parliament maintaining his original vote has been clarified since 9th. Professor Asare, who was contributing to a panel discussion on the Speaker's voting rights on Joy News following the Supreme Court judgment on the controversial legal debate, suggested that a judgment should have taken into consideration the historical antecedents of the Speaker's voting rights.
Experiences of 1969, the non-MP Speaker was retained, but this time it was decided that he'll be assisted. 1992 Constitution also retained. So when you do that evolution, you can learn a whole lot of things. So for instance, let's go back to the I'll have neither an original nor a casting vote, the Speaker. Okay? Remember, that Speaker was a member of Parliament. That Speaker was a member of the National Assembly, nor a casting vote. But more important, Article 42B of the 1957 Constitution provided that any person, including the Deputy Speaker, shall, when it specifically had a voice on whether or not the Deputy Speaker has an original or a casting vote, and it also told us that the MP learned some lessons. So we went to 1969. In the 1969 Constitution, at Article 82(1), it also nor a casting vote. And this is important because the Speaker at this time was not a member of Parliament. The Speaker at this time was not a member of Parliament. Speaker who is not a member of Parliament, it is directed to somebody who is a member of Parliament who performs the function of the Speaker. So in 1969, on the Deputy Speaker having an original, this drop was not some accident. It was constitutional framers looking at our history, looking at the 1957 Constitution, and learning from that and deciding that this notion that a Deputy Speaker or a person presiding will retain an original vote was obnoxious. Shall have neither an original nor a casting vote, and there's no reference to a Deputy Speaker. And finally, we have the 1992 Constitution, which basically copies from the 1979 Constitution and explicitly rejects the language of the analysis, is what I want to see when the court is making a determination as to whether from 1979 and 1969 is constitutional or not. Yes.